The 4 issues framed by my learned friend here are well canvassed by my colleagues here. You will permit me, Mr. Chairman, to add on to those 3 issues. But before I do so, Mr. Chairman, just 1, 2, 3 minutes to reinforce the 2 issues, the first 2 issues on Council Kalibara raised with authorities only. The arguments have been adequately canvassed, and we are convinced this Honorable Court is persuaded by those submissions. Now, with authorities on vagueness of Section 128, that is issue number 1. The vagueness, the uncertainty of that particular provision. The Constitutional Court has had occasion to pronounce itself on that particular matter in the case of Andrew Karamaji. I'll furnish you with a copy with you. Rather, I'll furnish you with a copy. Andrew Karamaji, Robert Shaka versus the Attorney General. It's Constitutional Petition number 5 of 2016. Kindly get me a copy to the judge. But the point emphasized here, Mr. Chairman, the doctrine of vagueness in the legislation. This is what they said on page 10. This is the Constitutional Court. The doctrine of vagueness is founded on rule of law. The doctrine of vagueness is founded on the rule of law, particularly on the principles of fair notice to citizens and the limitation of enforcement discretion. Fair notice to the citizen comprises a formal aspect, an acquaintance with the actual text of a statute, and a substantive aspect, an understanding that certain conduct is subject to legal restrictions. The crux of the concern for limitation of enforcement is that the law must not be so devoid of precision in its content that a conviction will automatically flow from the decision to prosecute. The threshold for finding a law vague is relatively high, and this is what they set as a standard. The factors to be considered in determining whether the law is vague or not: A, the need for flexibility and the interpretative role of the courts, that is number 1. 2, the impossibility of achieving absolute certainty. A standard of intelligibility being more appropriate. That standard of intelligibility is critical and crucial. 3, the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. They cited the case of Nova Scotia Pharmaceutical. It is a 1992 decision which you will find here. So the doctrine of vagueness can be summed up in one proposition. This is how they summed it up, the Constitutional Court. A law will be found unconstitutionally vague if it lacks in precision as not to give sufficient guidance for legal debate. That is, for reaching a conclusion as to its meaning by reasoned analysis applying legal criteria. The term legal debate is not used. The term legal debate is not used to express a new standard or one departing from that previously outlined by this court. It is rather intended to reflect and encompass the same standard and criteria of fair notice and the limitation of enforcement discretion viewed in fuller context of analysis and the quality and limits of human knowledge and understanding in the operation of the law. The criterion of absence of legal debate And so it continues and continues. And finally, Mr. Chairman, this is the decision they arrived at after analyzing all of that. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators like this general court-martial is so extensive that it would lead to arbitrary prosecutions. I need to emphasize this. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators is so extensive that it would lead to arbitrary prosecutions. Vague laws involve three basic dangers, and this is what we want to caution against. This is what they stated. Vague laws involve three basic dangers. One, they may harm the innocent by failing to warn of the offense. Ignorance of law is not defense, yet the law itself is vague. Two, they encourage arbitrary and discriminatory enforcement because vague laws delegate enforcement and statutory interpretation to individual government officials. Laws are usually found void for vagueness if after setting some requirement or punishment, the law does not specify what is required or what conduct is punishable. Also, an enactment is void for vagueness if its prohibitions are not clearly defined. Finally, Article 28(12) is very clear. It requires that an offense must be defined. That definition, in my view, must be clear enough to enable citizens to distinguish between the prohibited conduct and the permissible one. Any vague interpretation will lead to satisfy the requirement of Article 28. They refer to the case of Charles Onyango versus the Attorney General. So this authority by the Constitutional Court, which has got that primary obligation of interpreting the Constitution, is binding on this federal law. And it's very instructive in that when you look at Section 128, it opens the floodgates. It cuts the net wide offenses relating to security. And punishment, death. This is how serious it is. So a vague law to subject somebody to a death penalty is something that cannot be sanctioned by the existing constitutional order. And the reason we are asking, we need interpretation of the Constitutional Court about that particular provision. So that is the authority in regard to the vagueness of Section 128 relating to offenses compromising security. The other issue, the second issue, again I will cite the authority, the issue relating to subjecting civilians to martial law, which my learned friend here adequately canvassed. But the authority, and he cited a number of authorities. Cited the ones of Uganda Law Society, cited ENYIMBA, and cited Kabaziguruka and a couple of others. But the point I wanted to emphasize, there are two authorities that have come subsequent to the decision of Kabaziguruka. The one of ENYIMBA, which is 2022, and it was very, very clear. And on that one, there was an appeal. The one of Yarugaba. Yes, the Attorney General appealed, preferred an appeal against the decision in the Kabaziguruka matter. But the one of Yarugaba, there is no pending. There is no any order of stay and no any other far order in that regard. My learned friend alluded to the fact that the other side may raise a contention that there was an order Kabaziguruka case. That has also been succinctly handled by the Constitutional Court, which took a decision in that case. They have decided it. One, in the case of ENYIMBA, but more sufficiently in the case of Semuju Abdul versus the Attorney General, Constitutional Petition number 4 of 2018. The most recent one, it is, to be exact, it is the 3rd February 2023. It is as fresh as these charges before you. This decision The lead judge, may his soul, Justice Kakuru, may his soul rest in eternal peace, had the occasion to reproduce verbatim the decision in the Kabaziguruka case. He summed them up and he said, the constitutionality, no, I have carefully listened and considered the submissions of both counsel on the constitutionality of sections 2, 119 and 197 of the UPDF Act. I have also carefully perused the affidavits and so on and so forth. The constitutionality of the issues raised above were substantially raised and settled in the recent constitutional decision of Honorable Michael Kabazuruka versus the Attorney General. That is constitutional petition number 45 of 2016. Then he said, I'll reproduce the declarations in extension for clarity. He highlighted them. I may not take your time, but they are very few. Yes? Yeah, just number 5. No. The general court-martial established under section this. No, number 2, the general court-martial's jurisdiction is only limited to trying service offenses under the UPDF Act. Then, he said, and 3, military law under the UPDF Act must be construed to exclude laws that are the preserve of the civil courts of judicature. I will come to that later when I'm raising another issue. But more specifically, number 4, persons subject to military law. No. 5, sections 119, 1H, subsection 1 of section 179 of the UPDF Act are unconstitutional as they are inconsistent with Article 28 of the Constitution. That is a finding which is well captured in the decision of Kabaziguruka and reproduced in a number of those decisions. And they had occasion to make this finding after listening to the submissions of the state that in the Kabaziguruka matter there is an appeal, there is an order of state. This is what the Constitutional Court said after listening to the submissions, which are likely to come from the other side when they are replying. This is the response and the finding of the Constitutional Court. The above authority is good law, and I am bound to follow it. We are well aware that the above cited decision is currently pending appeal at Supreme Court. Until the Supreme Court decides otherwise, the authority is still good law. The fact that gave rise to this petition are almost on all fours with those in Honorable Kabaziguruka's case. Applying the above authority, I find that the petition is on all fours. The petition is therefore allowed on that account alone. The same declarations and orders in the Kabaziguruka petition apply to this petition. This is as of recent as 2023. So, this court, I'm afraid to say, its hands are now tied. It has no choice but to go by the declarations in the Kabaziguruka decision and reinforced in the decision of Semuju and Byarugaba and others which have come subsequent to the one of the submission I will make here. Again, in emphasizing the point Fred Mpanga he has raised of Article 3, any attempt by this General Court-Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court, with all due respect to the General Court-Martial, it will be treasonable. It will amount to treason for this General Court-Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution, Article 3, is very, very clear on observance of the constitutional order, respect to the given constitutional order and the interpretations given. So I urge you, Mr. Chairman, and members of the panel, not to commit treason by proceeding with this matter. Now, Mr. Chairman, with your permission, I beg to move and frame 3 issues. The first issue, in addition to the ones, the first one is about the propriety of the proceedings, the charge sheet canvassing, Mr. Chairman, Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws of both countries. So that is a matter which requires constitutional interpretation. Can there exist an extradition treaty outside? No, not a treaty, an MOU, yet the law provides for an extradition treaty. And isn't that a violation of Article 28 of the Constitution, which guarantees the right to a fair hearing and other relevant provisions? So I don't need to labor so much because we argued out that point earlier on. I would like to adopt the submissions we made earlier on about rendition in violation of the extradition laws. So I would like that matter also to be referred to the Constitutional Court. The other issue, Mr. Chairman, is the jurisdiction of this Honorable Court to deal with cases under the Firearms Act. Mr. Chairman, in this Kabaskuruka case, which is again reproduced in the subsequent decisions which I've just made reference to, particularly the one of Kusimu. So, clause 4, paragraph 4 of the decision. No. Paragraph 3. Military law under the UPDF Act must be construed to exclude the laws that are the preserve of civil courts of judicature established under Chapter 8 of the Constitution. And Mr. Chairman, this was a reinforcement of the decision in the case of Dr. Chiza Besije, the very person before you here, in Constitutional Petition number 12 of 2006, where it was adequately, again, handled by the Constitutional Court, that the offense is not the one whose particulars appear in the charge sheet. The offense in the charge sheet is under Section 3, by then it was Section 3, now Section 4 of the Firearms Act. That offense does not fall under Section 119. I'm sorry, it may not be that clear, the photocopying was not clear, Mr. Chairman. That offense, Section 3.1 of the Firearms Act, which is now Section 4 of the Firearms Act, and it canvasses count 3, 4, and 5. That offense does not fall under Section 119 of the UPDF Act. The offense of unlawful possession, ordinarily the monopoly of the UPDF forces. They said this offense is neither defined by any law in our statute books, nor has the sentence for it been prescribed. The said amendment of the charge, there was an amendment to the charge sheet, is clearly not helpful. They went ahead to say that government or UPDF attempted to come up with an instrument number 13 of 2006, ostensibly I think to address that lacuna. Uganda People's Defense Forces, arms, ammunition, and firearms, to define that phrase, monopoly of the defense forces. The court said that instrument was also redundant. And the beauty with this, my land friend here was still the judge advocate, was involved in this matter and is fully aware of the facts in this particular matter and all the attempts that were made to address those legal challenges. In other words, their finding was that you cannot widen the scope of Section 119 to bring into operation the provisions of the Firearms Act or any other law, including the Suppression of Terrorism Act, which is a preserve of the civil courts. That would be overstepping the mandate of the General Court Martial. I can say incarnation of the same here in this very charge sheet. So what ordinarily ought to have been done is to define that animal, which clearly the animal code offenses which are ordinarily a monopoly, no, weapons which are ordinarily a monopoly of the UPDF. Up to now, ever since this decision was made, the BCJ decision, this animal is still anonymous, undefined. And the attempt to do so in this instrument were also declared futile. So, Mr. Chairman, unless and until that phrase is unpacked and clearly dissected and explained, this General Court Martial cannot try offenses under the Firearms Act. So we would like that issue again to be also canvassed by the Constitutional Court. Finally, the issue I would raise is whether the arrest, conviction, and the detention of Counsel Aaron Chiza, one of the defense lawyers, amounts to violation of Article 28.3 of the Constitution. Mr. Chairman, Aaron Chiza is on record up to the present moment is one of the defense lawyers. And I'm glad when we raised it here and said, how do we cause the appearance of Aaron Chiza to execute his duties as per the instructions given to him and as per the record? There was preponderance of doubt. I read it on your mind. If I read you right, correct, Mr. Chairman. You say, is there a precedent to this? Did it happen that a person convicted can also come here? Then the judge advocate was of similar doubt. The only forum where that doubt can be cleared is the Constitutional Court. And the Constitutional Court has had occasion, this is the last authority I'm citing, in this case, it's one of the locus classicus cases on rights, fundamental rights, Article 28. Uganda Law Society and Jackson Kagaba versus the Attorney General. The lead justice, I think, was Mpajiba Yajoyi. They gave a purposeful interpretation. Of course, this is the command of the Constitution and rules of interpretation to Article 128. Article 28 rather. Each and every of the above Constitution, each and every of the above, rather not of the above Constitution, each and every one of the above constitute what the right to a fair hearing means. It was never intended that this would be an exhaustive definition of the right to fair hearing. Article 45 of the Constitution provides human rights and other freedoms additional to these rights. Mr. Chairman, during the trial here, during the hearing of the prayer we made about the appearance of our colleague Aaron Chiza, the judge advocate here indicated and said, but you see, Article 28 talks of the right to legal representation. It does not specify the numbers. The answer lies in this decision. That Article 28, which talks about the right to a fair trial is not even exhaustive when it talks about those key elements. It's the reason the CA had to insert Article 45. That there are situations that may arise that would warrant one more than what you can even see. Why Aaron Jesus is indeed needed in this case can only be answered by the person who gave him instructions. He knows the reason, and he should be facilitated to prepare his defense. And one cannot say, just especially from the other side, from the judge advocate, that what role is he going to play when the accused person has got over 30 or 40 lawyers. The prerogative rests with him to determine who should be there, who shouldn't be there, and to have a lawyer or lawyers of his choice. That is the language of the Constitution. Aaron Chiza remains his lawyer of choice for a reason which should not be derogated, because that is a non-derogable right, the right to a fair hearing. Article 28 and 44 is a non-derogable right. So I reiterate the prayers made. I will not go into other issues. I beg that Mr. Chairman and honorable members that you proceed to do what is commanded by Article 137 to refer this matter to the Constitutional Court. I beg to move.